Welcome to a discussion of contracts to make a will. Corresponding PowerPoints have been posted that you can track through as I proceed through this discussion. PowerPoint 1 is a skeletal outline of our topic. Contracts to take or to make a will can take several different forms. You can have a contract to make a gift by a will. You can have a joint and or mutual wills, or joint and mutual wills. I'll discuss the difference in a moment, that may or may not be contractual. You can have a contract not to revoke a will, a contract not to revoke a provision of a will, or a contract to not make a will at all. As far as the purpose underlying these contracts, why do we have them? Some estate planners use contracts to make a will. You may also see these contracts in the context of businesses. One partner may execute a contract to make a will to protect the business for the purposes of the other partner. You may also see contracts to make a will in the context of personal service agreements, meaning one person cares for another person during their life on the understanding that they will be compensated through some type of gift after death. Now, what is a joint will, which is something that I mentioned just a moment ago? A joint will is usually executed by a married couple. It is a single document executed by at least two people on the same piece of paper. The document, it is intended that both people on the document be a signatory as they die. In effect, the same instrument is going to be submitted to probate for each signatory, as if the piece of paper was two separate wills or two separate pieces of paper. Usually a joint will is a bad idea. The good news is that joint wills are seldom used. Usually joint wills include a clause that says that the joint will cannot be changed after the death of the first signatory. Some states, such as Wisconsin, do not allow joint wills. And I would mention as an aside that a trust generally accomplishes many of the purposes for which joint wills were or are used. PowerPoint 2 in the PowerPoints posted online provides you with a definition of a joint will. Moving on to PowerPoint 3, what is a reciprocal or a mutual will? A reciprocal will is more than one will. It would be separate pieces of paper, and the pieces of paper, the terms of these two wills mirror one another. So, for example, husband's will would say all of my property to wife if she survives me. If she doesn't survive me, to our children. And wife's will would provide all of my property to husband if he doesn't survive me, to our children. Now, the term mutual will may simply be another term for a reciprocal will, or it may be a term used to refer to a joint will or a reciprocal will executed in accordance with a contract. So the term mutual is being used to represent mutuality in the contract. You may also hear the term mutual will contracts. What is a joint and mutual will? It is when each signatory is bound to the underlying provisions of a contract. Most people entering into mutual wills do not realize that they need an underlying contract not to revoke, and that separate contract can sometimes create issues. Now, contract law adds a layer of complexity here. The issue of contracts to make a will, the contract is governed by contract law, not the law of wills. So we need to do a contracts analysis, offer, acceptance, meeting of the minds, consideration. There are no testamentary formalities for a contract to make a will. We do not probate the contract. The effect, if there is a breach of the contract, is that we have a cause of action against the estate of the promisor. We don't oppose probate of a properly executed will just because there's a breach of a contract that is tied to the will. We file an action in civil court for usually breach of contract. If a properly executed instrument, testamentary instrument, is inconsistent with the terms of a contract and therefore results in a breach of contract, we have a number of different options. We can file an action for damages. We can seek quantum meruit. We can impose a constructive trust so that the property goes where it was supposed to go. The general rule is that contracts to make a will are supposed to be in writing. Now, it's not necessarily fatal when the contract to make a will is not in writing, but it certainly is a lot tougher. We are suspicious of these claims after the death of the decedent that there was an underlying contract. Now let's consider UPC 2-514 and the Nebraska statute, which are both on point and substantively identical on this topic. If you look at PowerPoint 4, you can compare one to the other. The UPC and the Nebraska statute both require that a contract to make a will be in writing in order for it to be enforced. These provisions effectively do away with oral contracts to make a will. It does not prevent a claim from being brought for equitable reasons, quantum meruit, equitable estoppel. So equitable principles in contract law can potentially be used to provide a remedy when there is an oral contract. One of the interesting features of these statutes is the last sentence that states that the execution of a joint will or mutual wills does not create a presumption of a contract not to revoke. Why have this provision? Because courts have interpreted the language we or us in a joint will as implicitly creating a contract. There has actually been a lot of litigation in this area, whether or not there is a contract not to revoke, even though there's no underlying contract. And so this language in the UPC was meant to clarify that the pronoun use does not create a contract. There is in fact not a contract unless there is actually a contract. As I mentioned to you a moment ago, we will enforce oral contracts if certain conditions are met. Now, in almost every jurisdiction, a writing is required if real property is involved, and I would say you have a very significant, if not insurmountable, statute of frauds problem if real property is involved and there is no underlying contract. Interestingly enough, Creighton Law Review published an article on oral contracts to make a will in 1987. The author's last name is Collins. It is extremely easy for somebody to claim after the death of the decedent that they had a contract with the decedent. It was the subject of a great deal of litigation, which is why the UPC drafted the statute that it drafted. In many states, as I said, there was a presumption. There was a presumption if you had a joint will or if you had mutual wills that there was an underlying contract. The typical facts that one sees can be or set forth on PowerPoint 5. Husband and wife orally agree to leave their properties to the survivor, and the survivor then to leave the estate to A, B, and C. Husband dies first, leaving a will conforming to the contract. W takes H's property. W now executes a new will, leaving her property to the gardener. A, B, and C can try to enforce W's obligation despite the absence of a writing. Several theories can be argued. There is a special difficulty here because it is an oral contract. I would look at whether or not there is a claim for fraud. Did W never intend to honor the agreement that she had with H? You would also proceed to look at detrimental reliance and estoppel. In other words, W will be estopped from asserting a statute of frauds defense after W's accepted the benefits under H's will. W's estopped to ensure no unjust enrichment, and the court may impose a constructive trust on the estate of W to get the property back to A, B, and C. The problem here being that W accepted the benefits from H and then went ahead and ignored the contract, and so we should stop W from ignoring the contract because otherwise we would have unjust enrichment. Let's look now at PowerPoint 6. Let's talk about the remedies for breach when the first party dies in compliance. So we have the fact pattern set forth on PowerPoint 6. A and B have executed reciprocal wills pursuant to a written contract not to revoke. A has died with her will in the agreed to form. B has accepted the benefits under A's will. B should now be bound by the contract, but assume that B revokes the agreed to will and executes a new will in violation of his agreement with A. What are the remedies? First, if B dies having wrongfully revoked his will with no other will in place, let's talk about that variable. Is that a breach of contract? The answer is yes. Does the breach affect or change the fact that B's estate will be distributed under intestacy? The answer is no. What about looking at PowerPoint 7, if B dies wrongfully having revoked his will and he has a new will, so we'll say will number 2 in effect. Is this a breach of contract? Yes, absolutely. Does the breach affect or change the fact that B's estate will be distributed under will number 2? The answer is no. The rightful beneficiaries should seek a remedy. They're going to seek a remedy through civil court. They may, if the property is unique and damages at law are insufficient, request that a constructive trust be imposed in their favor. Next, looking at PowerPoint 8, B attempts during his life to dispose of property that is covered by the agreement with A, either property received from A or the property of B that is subject to the agreement. Once again, the beneficiaries may wish to seek to have a constructive trust imposed on the basis of fraud on the part of B or unjust enrichment. Next, we have assume B revokes the will in violation of the contract but makes no inter vivos transfer. The rightful beneficiaries in that situation can bring no action against B during B's lifetime on account of his revoking the will because they've not been damaged yet. I suppose in contract there may be the argument of anticipatory breach, possibly, but otherwise they cannot yet bring an action. Let's look at PowerPoint 9. PowerPoint 9 addresses the circumstance when the first party dies in breach. So A and B execute reciprocal wills pursuant to a contract. Assume that A dies having revoked her will. B survives. Does B have a remedy? Interestingly, many courts deny relief in this situation on the argument that B has not been damaged. B is still alive. Because B is still alive, B can execute a new will, thereby avoiding any damage. It seems to be the assumption by courts, either rightly or wrongly, that a contract to make a will remains revocable until one party dies. Now, these questions, when you see them arise, require that you do usually both a contracts analysis and a wills analysis. So looking at PowerPoint 10, under the wills analysis, you look at whether or not the will is valid, and you also look at whether or not possibly there has been a valid revocation. Under the contracts analysis, you are looking at whether or not there is a valid contract. So offer, acceptance, consideration, meeting of the minds. And then has there been a breach of that valid contract, followed by what remedy can the party seek or the victim of the breach seek? The remedies are different for breach of contract than what we've customarily discussed in a wills and trusts class. Now, as a side note, it is worth mentioning that you cannot enter into a contract where you receive money for the care of your spouse. That is against public policy. You can enter into a contract where you receive money for the care of anybody but your spouse. So a neighbor, a friend, a relative. It is a not uncommon situation in which these contracts arise. PowerPoint 11, how does a contract to make a will interact with a will? And PowerPoint 11 compares side by side the will aspect of this to the contract aspect of this. Now, PowerPoint 12 is a bar exam question from February of 1999. A very interesting PowerPoint question that was a contracts of will crossover question. So how would we address this? First, we would look at the validity of the 1990 will. So in this question, in 1990, H and W both executed wills, and the facts stipulate that the wills of both H and W are valid. If the facts did not stipulate to validity, you of course would track through whether or not there was present testamentary intent, and then whether these instruments were valid as formally executed instruments? So do we have two witnesses? Were presence requirements met? Or alternatively, are these two instruments valid as holographic instruments? Second, we would talk about reciprocal wills. In this fact pattern, the wills were reciprocal, and that means that H and W had each a separate will that mirrored the terms of one another. The terms of the will: property passes from the last surviving spouse to the children. There are two children, C and D, and we next progress to an examination or a consideration of the will's contract. Now, our general rule is that parties are free to contract to make a will, to not make a will, to revoke a will, to not revoke a will. However, even if a contract exists, a breach by one of the parties is not going to affect the will or intestacy. The aggrieved party must look to contract remedies. The parties in this fact pattern orally promised in the presence of S and B to never revoke their wills. It should be noted that the presence of reciprocal wills does not create a presumption of a contractual agreement. So at least in this fact pattern, the validity of the contract hinges on an oral promise. It is worth noting that C and D, the children, are third-party beneficiaries to the contract because they stand to benefit from the contract between H and W. As far as the validity of an oral contract, we know that this oral contract does not meet the requirements that are set forth under the UPC or set forth in the Nebraska statute. We would consider whether or not the non-breaching spouse could pursue a remedy under equity principles whether C or D could pursue a remedy under equitable principles. So detrimental reliance, and maybe we would look at the constructive trust and or specific performance, because we have W breaching an agreement on which H relied to the detriment of C and D, the children, and the breach may cause, or the breach does in this circumstance, cause unjust enrichment. And that takes us through that question and finishes up coverage of contracts to make a will.